listener production.
A story that changed a nation. A fight for justice, recognition, and the rights of the First Nations people. From little things, big things grow, as Paul Kelly so powerfully reminds us. We'll explore the journey of Eddie Mabo, the High Court battle, and its legacy. This is a story of courage, law, and the enduring impact of standing up for what's right. I'm Dan Mullins. This is Crime Insiders Judgment, a deep dive on a judge's final verdict of a crime and what transpired to incite that judgment. Before the ships, before the flags, before the very idea of Australia as we knew it, there was a vast continent, alive with stories, with peoples, with laws as ancient as the land itself. On a small island in the Torres Strait called Mur, the Meriam people lived by a wisdom passed down through countless generations. They knew their land, every garden, every fishing ground, every sacred site, not as a possession, but as an extension of their very being. Their maps weren't on paper, they were etched in memory, in custom, in song. This was their truth, their unbroken connection. Then in 1788, another truth arrived, a truth declared from the deck of a ship in Sydney Cove under a new flag. The British Crown, by decree, proclaimed this immense continent terra nullius, land belonging to no one. It was a legal fiction, a convenient untruth that allowed them to plant their flag and claim a continent, dismissing millennia of human habitation, complex societies, and intricate legal systems. In a stroke, First Nations people became trespassers on their own ancestral lands. This legal fiction wasn't just abstract, it had devastating consequences. It allowed for conquest by paper. It laid the foundation for every law, every land grant, every interaction. Consider an early chilling account from 1836, the criminal case of the Crown versus Murrell. Jack Congo Murrell, an Indigenous man, was on trial for murder, a murder of another Indigenous man. His defence was stark, profound, and utterly rejected by the colonial court. The defence argued that British law shouldn't apply because the First Nations people were a sovereign nation with their own laws, their own justice. But the judge, beholden to the myth of terra nullius, swept it aside. The law, he declared, applied to everyone simply because the land was deemed empty. This wasn't just a criminal trial. It was a foundational moment, legally entrenching the dispossession that would continue for generations. Fast forward to the 1930s, back on the island of Mur. A young boy named Edward Koiki Mabo grew up amidst the vibrant life of his people. He was steeped in the land, in its stories, in the Meriam way of knowing who owned what garden, what patch of trees, where the fishing grounds lay. His adoptive parents, Benny and Mega Mabo, were his first teachers, instilling in him the deep knowledge that this land was theirs, passed down through bloodlines and ceremony. This was his living truth, a truth entirely at odds with the legal fiction declared a continent away. As Eddie Mabo moved to the mainland in the 1960s, a new truth hit him, a harsh reality of injustice. He saw the systematic discrimination, the poverty, the denial of basic rights for Indigenous Australians. He became an activist, a fierce advocate for his people. And then, at James Cook University, he encountered the words that would ignite his life's defining battle: terra nullius. He learned the legal basis for his people's dispossession, The land he knew belonged to his family, his ancestors, was, according to Australian law, nobody's land before the British arrived. In the 1970s, the Queensland government passed legislation that effectively claimed ownership of all Torres Strait Islander land, including Murray Island, under Crown land rules. This ignored the traditional land ownership of the Murrian people. Having grown up on learning traditional laws and customs about his family, about land ownership and inheritance, he saw the contrast between Murrian custom law and Australian law, where his people had no legal claim to their ancestral land. Mabo became active in local issues and education, learning about broader Indigenous rights movements. This awareness sparked the idea that the legal system could recognise traditional land rights. And then in the early 80s, the Queensland government passed the Queensland Coast Islands Declaratory Act, which retroactively extinguished any native title claims in the Torres Strait. This was a direct affront to the Murrian people's rights and prompted Mabo to take legal action to challenge the state's claim. Eddie Mabo wondered, how could this be? How could this ancient living culture be legally invisible? That moment, that realization, was a turning point. It forged a resolve that would not break. He would challenge this lie. He would prove in the highest court of the land that his people's connection to their land was real, lawful, and had never been extinguished. He found allies, the academic Henry Reynolds, and later the lawyers Brian Keon Cohen and Ron Caston QC. With 4 other Murrian people, Reverend David Passy, Sam Passy, Salua Mapo Sali, and James Rice, they embarked on an epic legal journey, a journey that began not in hope, but in righteous anger. The legal battle began in 1982. It was not a quick fight. It was a grinding, decade-long marathon against the full might of the Queensland state government and eventually the Commonwealth. The stakes were immense, not just for the Murrian people, but for every Indigenous person in Australia. If terra nullius could be overturned for then perhaps it could be overturned for the entire continent. Queensland's reaction was immediate and desperate. The Coastal Islands Declaratory Act was a last-ditch attempt to extinguish any potential native rights retroactively, to wipe them out before the High Court could even rule on them. It was a cynical move, an admission of fear, and it showed just how much was at stake. But the Mabo team fought back. Queensland Coast Islands Declaratory Act became the subject of the first High Court challenge. This first case, often called Mabo No. 1, was a crucial preliminary victory. In 1988, the High Court ruled that Queensland's attempt to extinguish native title was invalid because it directly discriminated against the Murrian people, violating the Racial Discrimination Act of 1975. It was a clear signal the High Court would not allow a state to simply legislate away Indigenous rights. The path was now clear for the substantive native title claim to proceed. One of the most extraordinary phases of the case involved a unique legal process, a fact-finding mission. Justice Martin Moynihan of the Queensland Supreme Court travelled to in 1989. For weeks, the court sat on the island. Murrian elders, including Eddie Mabo, gave evidence. They walked the land. They pointed to the trees, the rocks, the boundaries. They described their intricate customary laws of land tenure, demonstrating a living, unbroken connection to their ancestral lands for generations. It was about translating the wisdom of millennia into the rigid language of common law. They told the court of their ancient kinship systems, their inheritance laws, their spiritual connection to the land and sea. The Meriam elders presented their own maps to Justice Moynihan. These weren't European-style cadastral maps. They were intricate drawings and oral accounts of garden boundaries, fishing zones, and ancestral pathways passed down through generations. They spoke of the rocks, the trees, the subtle shifts in terrain that marked their inherited plots. The locals laid bare their sovereignty, not as a political statement, but as a lived reality. Justice Moynihan's findings, though complicated by some interpretations, ultimately affirmed much of their traditional connection to the land. This evidence would be critical when the case reached the High Court. But the years dragged on. The physical and emotional toll on Eddie Mabo and the other plaintiffs was immense. For Eddie, a heavy smoker, the stress and the weight were crushing. His health deteriorated rapidly. He fought so hard for so long, driven by an unshakable belief that justice must prevail. He held on to the hope of seeing the final judgment, of hearing the words that would validate his people's truth. But time was running out. Coming up, the High Court of Australia considers Eddie Mabo's challenge. Behind the closed doors of the High Court, 7 of Australia's most eminent legal minds grappled with the weight of history. This wasn't just a legal puzzle, it was a national reckoning. Could the common law, built on the foundations of colonial power, truly evolve to acknowledge the prior sovereignty of Indigenous peoples? Could a legal system that had denied rights for over 2 centuries suddenly recognise them? The deliberations were intense, the arguments profound. The future of a nation, its very self-understanding, hung in the balance. Before we get to the High Court, Gough Whitlam was Australian Prime Minister from 1972 to 1975. He was a supporter of Indigenous land rights. His government initiated land rights commissions and legal inquiries in various parts of Australia, including encouraging legal recognition for traditional ownership. Whitlam famously said, "I want to acknowledge that we Australians have still much to do to redress the injustice and oppression that has for so long been the loss of black Australians." Whitlam's approach to Indigenous land and legal recognition helped create the political climate in which Mabo could eventually take his case to the courts. Whitlam famously visited the Northern Territory settlement known as Jageragu. The Whitlam government had handed back 3,250 square kilometres of Gurindji country to its traditional owners. Gurindji elder Vincent Lingiari and Mr. Whitlam reenacted the handing over of the title deeds for the land. Vincent Lingiari and around 200 others had won a dispute to reclaim the land after walking off in protest against the conditions they faced as employees on Wave Hill Cattle Station southwest of Katherine. The Whitlam government had provided Commonwealth funding to purchase land that was not deemed to be on what were called at the time reserves. A British company that owned Wave Hill surrendered the land and it was officially handed back to the Gurindji people. In a famous symbolic gesture, Lingiari held the deeds to the land in his left hand. Whitlam then poured a handful of red earth into Lingiari's right palm. Whitlam said that this is a sign that this land will be in the possession of you and your children forever. It marked the very first occasion where the Australian government had returned land to its original owners. The tide was turning. The Mabo case wasn't just about a small island in the Torres Strait. It was about the very foundations of Australian law. For almost 2 centuries, Our legal system operated on a bedrock principle, terra nullius, the idea that when the British arrived, Australia was a land belonging to no one. This wasn't just a casual observation. It was a powerful legal doctrine that dictated how land was owned, how laws were applied, and how Indigenous peoples were treated. To understand the magnitude of Mabo, we first need to grasp the legal landscape the plaintiffs were challenging, the prevailing legal orthodoxy stemming from the settlement of Australia rested on two key propositions. That upon British acquisition of sovereignty, the Crown acquired absolute beneficial ownership of all land in the territory. This meant that any pre-existing Indigenous rights to land were automatically extinguished. The Crown effectively became the sole owner from day one. The second proposition was that the common law of England, as far as it was applicable, became the law of the new colony, and by that law, no Indigenous property rights were recognised. The colonial legal system simply did not see a form of ownership that matched English concepts. Thus, it saw nothing to protect. This was the direct consequence of the terra nullius fiction. The Murrian plaintiffs, led by Eddie Mabo, had to confront this established order head-on. Their legal team argued that these foundational propositions were fundamentally flawed, both historically and legally. Their core arguments were: terra nullius was a fiction based on a discriminatory premise. They argued that the idea of empty land was patently false. Anthropological and historical evidence clearly showed complex, organised societies with established systems of land tenure and governance. They argued that the common law could and should evolve to reflect contemporary understandings of human rights and justice, rather than cling to an outdated and discriminatory historical fiction. A second key argument related to sovereignty versus radical title. The plaintiffs conceded that the Crown acquired sovereignty, the ultimate power to govern, but argued that this did not automatically grant the Crown absolute beneficial ownership of all land. Instead, they proposed the concept of radical title, which is merely a skeletal title, giving the Crown power over the land but allowing for pre-existing native title to coexist. This was a crucial distinction. And finally, they argued native title exists and was not extinguished. They contended that where Indigenous people maintained a continuous connection to their land according to their traditional laws and customs, their pre-existing rights, which they termed native title, continued to exist. These rights were not granted by the Crown. They survived the acquisition of sovereignty. The Queensland government, on the other hand, staunchly defended the traditional view. Their lawyers argued for the absolute power of the Crown. Their key counter-arguments were the settled colony doctrine. They maintained that Australia was a settled colony, not conquered or ceded. Under English common law, in a settled colony, the Crown acquired absolute ownership of all land from the moment of settlement. To argue otherwise, they claimed, would unravel centuries of property law and create chaos. They also argued what was called parliamentary supremacy. They asserted that the Parliament of Queensland and the Commonwealth had always had the power to legislate with respect to land, and any such legislation, even if it didn't explicitly mention native title, implicitly extinguish any such rights simply by creating a new system of land tenure. And finally, Queensland's legal team argued against what they called impracticality and uncertainty. They warned of the immense practical difficulties and legal uncertainty that would arise if native title was recognised. It would, they argued, destabilise land titles, affect mining and pastoral leases, and disrupt established economic activity. They painted a picture of widespread chaos. The High Court was thus faced with a profound dilemma. Upholding the existing law meant perpetuating a grave historical injustice. Changing it meant fundamentally reinterpreting the very foundation of Australia's legal system. The pressure was immense. On the 3rd of June 1992, the High Court of Australia delivered its judgments in Mabo v Queensland No. 2. Eddie Mabo had passed away just months earlier, in January of that year, never hearing the words that would etch his name into history. But his spirit, his struggle, filled that courtroom. While the majority of the High Court, led by Justices Brennan, Mason, Dean, Toohey, Gaudron and McHugh, agreed on the core outcome, their reasoning differed slightly on some points, but their shared conviction was clear. The common law had to evolve. However, there was one dissenting voice, Justice Dawson. His judgment articulated the very fears the Queensland government had raised. He argued that overturning terra nullius would plunge Australia into legal chaos. He adhered to the view that the common law of England, as introduced into Australia, did not recognise any pre-existing native rights to land. For him, the implications of departing from such a long-standing principle were too profound, too destabilising for the settled system of property law. He represented the deep-seated anxieties about what this radical shift would mean for the nation. Presiding Judge Justice Gerard Brennan said in the High Court of Australia on the 3rd of June 1992, "The fiction by which the rights and interests of Indigenous inhabitants in land were treated as non-existent was justified by a policy which has no place in the contemporary law of this country." With those words, Justice Brennan, delivering the majority judgment, tore down the foundation of colonial Australia. He declared terra nullius a legal fiction, a lie. It was an acknowledgement that Indigenous peoples existed, that they had laws, customs, and an unbroken connection to their land before 1788. Justice Brennan said, "Native title has its origins in and is given its content by the traditional laws acknowledged by and the traditional customs observed by the Indigenous inhabitants of a territory. The nature and incidence of native title must be ascertained as a matter of fact by reference to those laws and customs." This wasn't a grant of rights from the Crown. It was a recognition of rights that had always existed. It meant that Indigenous Australians, under certain circumstances, still held title to their ancestral lands where that connection had been maintained and not extinguished by inconsistent Crown grants, like freehold or exclusive leases. The court ruled the Crown's acquisition of sovereignty over the territory of a continent did not extinguish the native title to the land where the Indigenous inhabitants continued to observe their laws and customs and to live on the land. Justice Brennan said, "In discharging its duty to declare the common law of Australia, this court is not free to adopt rules that accord with contemporary notions of justice and human rights, if their adoption would fracture the skeleton of principle which gives the body of our law its shapes and internal consistency. Australian law is not only the historical successor of, but is an organic development from the law of England. Although our law is the prisoner of its history, it is not now bound by decisions of courts in the hierarchy of an empire, then concerned with the development of its colonies." Justice Brennan explained what native title was, not a static concept, but one derived from the traditional laws and customs of Indigenous peoples. Its content could vary, from rights to hunt and gather to more extensive rights akin to communal ownership. And crucially, he outlined how it could be extinguished only by a clear and plain intention of the Crown through inconsistent grants like freehold title or by appropriation for inconsistent public purposes. Mere settlement, he concluded, was not enough to extinguish it. The nation reeled. For Indigenous Australians and their allies, it was a moment of profound vindication, a cry of joy, decades in the making. For many others, particularly in industries built on land exploitation, it brought fear and uncertainty. The media exploded. Politicians grappled with the implications. The judgment demanded a new national conversation about history, land, and reconciliation. The immediate aftermath saw the creation of the Native Title Act of 1993. This landmark federal legislation was an attempt to provide a framework for the determination and protection of native title. It was a complex, often controversial piece of lawmaking, born from immense political pressure and compromise. It was a step forward, but by no means a perfect solution. The fight for justice, for land, for recognition continued in a new legal arena. Eddie Mabo never saw the victory, but his family, his community, and indeed the entire nation reaped the benefits of his courage. He was posthumously awarded the Australian Human Rights Medal, and his name became synonymous with the dismantling of a colonial lie. His body was returned to Mur, reburied in traditional ceremony, his resting place now a sacred landmark. The legacy of Mabo is still unfolding. It fundamentally changed property law in Australia. It opened doors for land claims, for negotiations, and a deeper understanding of Indigenous heritage. While Mabo was a civil case, its implications touched every aspect of Australian law, including criminal justice, by shifting the very paradigm of who owned the land and thus whose laws might apply in certain contexts. It acknowledged that Aboriginal and Torres Strait Islander laws and customs exist and persist, challenging the absolute assertion of Crown sovereignty implicit in prior legal decisions like the Crown versus Murrell. But Mabo wasn't the end of the journey. It was a profound beginning. It did not fully erase 2 centuries of dispossession, nor did it fully bridge the chasm of understanding between Indigenous and non-Indigenous Australia. It was a recognition, not a grant. The work of reconciliation, of truth-telling, of achieving genuine justice for First Peoples continues. It is a story still being written, etched not just in legal documents, but in the ongoing efforts to acknowledge, to respect, and to walk together on this, the unceded earth. As we close today's episode, we remember Eddie Mabo's courage and the ripple his fight created. From little things, big things grow. A simple truth that shaped the law and the land. The story of Mabo reminds us that justice can be pursued, even against great odds. Change starts with a single voice, a single stand, and a belief that it matters. Thanks for listening to Crime Insiders Judgements. We love hearing your feedback, so please rate and review this episode. If you have a case you want us to cover, let us know via Instagram at Listener Crime or TikTok at Listener Crime Team. I'll be back again next Thursday with another case. I'm Dan Mullins, with sound designed by Niall Fernandez. This series was recorded and produced on Gadigal land.